In this short video series, we are aiming on attempting and break down the questions that are given in the University of London exam papers. Our focus is to address and cater our answers to the expectations, guidelines, requirements of the examiner rather than writing short notes. So in this short video series, we will go through certain most commonly repeated questions at the exam at University of London exams for both first year, second and third years, and we will give you a very basic 2 minutes breakdown of these questions. Hopefully these breakdowns will help you to enrich your answers and score well, get a good first classes, second uppers at the exam. Wish you all the best and stay tuned with this video series. Discuss the impact of Human Rights Act and European approaches to statutory interpretation. This is again a common popular question for LSM exam papers. Often for a question like this, students get stuck with the basic approaches such as literal rule, golden rule, mischief rule in their answers. But here they are focusing a lot on European approaches. So indeed, for a question like this, I would recommend you to break it into 4 parts. First part would be your introduction and highlight the fact that European influence are tremendous when it comes to statutory interpretation in UK. Secondly, make sure you talk about different approaches: literal approach, golden approach, mischief approach, purposive approach, different rules of languages such as noscit associis, ejusdem generis. Thirdly, and most importantly, you should focus on Human Rights Act Section 3(4). This should be the bulk of your answer. Since they're asking also about European approaches, you should focus on EU Law Section 2(1) of the European Community Act of 1972 with direct effect, especially indirect effect in your answer, with focus, right? With focus on a little bit on Brexit as well. Finally, you can conclude and argue the power of judges in terms of statutory interpretation. Have these acts, have these European approaches emboldened and empowered the judges to now leave their roles as interpreters, but rather to become to take roles of legislative. So you should focus on the increased tension between the Parliament and the judiciary in the wake of Human Rights Act cases and EU cases. So make sure you focus on that last parts well in your answer. You should focus on the classic approaches, but that should probably be 20% of your answer. 80% of your answer should focus on the influences of the European styles, European approaches, Human Rights Act and EU law. All the best.